I am honored to be here, and that is especially so because I'm honored to have been asked to represent the Marshall Islands in this terrific, extremely important case before the International Court of Justice. There aren't that many cases that the International Court of Justice is dealing with, and not all of them are as interesting as the other ones, but they're all signs of civilization. This case certainly is a case which is outstanding in its importance, and I'm very happy to be able to be part of that. This morning the court sent me a letter of acknowledgement stating that it had received in good order the 9 applications that we submitted to the court last Thursday. And the court indicated that now the procedures that are to follow have started. And I hope to be able, through our team, to keep everyone that is interested in this updated in about each and every step that will follow. Of course, there was some preparation that went ahead of this submitting of these cases, but the first part of that was that the legal team that was put together for these cases advised the Marshall Islands that bringing this case is an entirely responsible thing to do given the state of the law today. It's been said many times that it's very courageous of the Marshall Islands to initiate these cases, and of course it is. Although one may question whether it would be, of course it is, because we're just talking about breach of contract. And breach of contract is the common ground in most forms of litigation in national, regional, and international courts. That is the basis of the case, pure breach of contract. And usually nobody says that it is courageous to bring a case about breach of contract to any court. So there must be something here, but I'll leave it to others to explain that. But in any event, if any one state is not getting what it is entitled to based on a contract or based on a treaty or based on norms of customary international law, there comes a day that such a state will stop requesting politely, as many states have done for decades now, will stop requesting politely and will bring the states that are not delivering to court. And since in July 1996 the advisory opinion was delivered, there has been on a yearly basis a politely asking by the far majority of the states assembled in the General Assembly of the United Nations to give a proper follow-up to the opinion. And the court has led the way, and the only question that was put down in the resolution was, do what you're supposed to do. The court has told you so. However, most of the nuclear-armed states wouldn't have that and ignored the polite request. And so here we are with 9 cases now in court. I'm saying 9 cases, but actually today there are only 3 of the 9 cases in court, because 3 of the states that we're talking about, United Kingdom, Pakistan, and India, those 3 have accepted the compulsory jurisdiction, the jurisdiction of the court on a compulsory basis by a solemn declaration. And actually we need to give them credit for that, because it's a very civilized thing to do, to accept compulsory jurisdiction of the court, and it's too bad that a majority of states has not done so thus far. The other 6 states we're talking about, the United States, France, China, North Korea, Israel, France, let's not forget about France, they have not recognized the compulsory jurisdiction, or they have withdrawn that, as France and the United States has done, after they got sued. France was sued about the nuclear testing and didn't like that idea and withdrew its consent to jurisdiction, and the US did the same when Nicaragua came after the United States. In our case, most of the 6 states that have not accepted the jurisdiction do take the public position that they are totally in line with what the law tells them to do. And we think that in this particular case, it would therefore be only right for those 6 states to come to court and explain that and have the debate in full about what the legal obligations are about. That would be a consequence of their own repeating, we are strictly abiding by our obligations. And we'll have to see within the next couple of weeks whether they will inform the court whether they're coming or not. And from that point onwards, if any of the 6 states will inform the court they're accepting the court, we won't have 3 but 4, and maybe that will add up to 9 cases at a certain point. I just want to make a very few comments on the advisory opinion of 1996, because I trust that most of you are familiar with the wording of it. Some people think, maybe not most of the people in this room, but some people think and state that this is not a judgment, it's only an advisory of the International Court. It's true, it's not a judgment. It's not been the end of a litigation between 2 states, and the winning state is not able to go to the Security Council and ask for enforcement. But the advisory opinion is explaining and analyzing the law and telling what the law says today. And from that perspective, it is as binding and as authoritative as any other judgment of the court. And the court itself does treat its advisory opinions in that particular way. In its advisory opinion, the court went into the details of the question on legality of use and threat of use. But besides that, and in the context of that question posed by the General Assembly, the court provided additional analysis. And I quote very briefly, the court gave an important observation. It said, in the long run, international law, and with it, the stability of the international order which it is intended to govern, are bound to suffer from the continuing difference of views with regard to the legal status of weapons as deadly as nuclear weapons. And the court continued, it is consequently important to put an end to this state of affairs. The long-promised complete nuclear disarmament appears to be the most appropriate means of achieving that result. That's not a politician speaking, that's not the majority of the General Assembly speaking, but that's the International Court of Justice speaking. And from that starting point, the court went ahead and stated that it, I quote, that it appreciates the full importance of the recognition by Article 6 of the Treaty on the Non-Proliferation of Nuclear Weapons of an obligation to negotiate in good faith a nuclear disarmament. So the court treated the Article 6 obligation as a recognition of an obligation to negotiate. And that's a very important finding, which is reflected in the end finding of the court, which says there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament in all aspects under strict and effective international control. So the court provided this additional analysis, and the existing obligation is formulated by the court in no uncertain terms. The way the court's analysis is set up in the opinion and the explanatory statement of its president, President Bedjaoui, are the foundations for the cases that we're discussing today. Without that, I don't think that we would have had a very clear and strong basis to go to the court and say, well, please implement what you've said before. It's a very important part of the advisory opinions. In each of the 9 applications, which are just the beginning of the cases, literally, but also as far as substance is concerned, we only highlight the main things, the most relevant facts, the most relevant parts of international law that the cases are based upon. And we argue, among other things, that the upgrading and modernizing of a state's nuclear arsenal is not particularly providing evidence of respect for the legal obligation to bring the nuclear arms race to an early cessation. And in legal terms, this is that it demonstrates that the respondent state is not performing its legal obligations in good faith. The Marshall Islands also argues in the cases that the continued refusal of most of the nuclear armed states to even permit the commencement of negotiations on complete nuclear disarmament, or even refuse to participate in such thing as an open-ended working group aimed at facilitating such negotiations, is evidence of their breaching the central obligation to pursue and to bring to a conclusion. We asked the court to adjudge and declare that the respondent states are performing their obligations, not acting in good faith, and also to adjudge and declare that the respondent breaches the obligation to pursue and conclude negotiations, obligations flowing from Article 6, but also from the customary international law. Also, in each of the cases, we asked the court to order the respondent state, to order each one of the respondent states to, within a year after the delivering of the judgment, pursue by initiation, if necessary, negotiations leading to nuclear disarmament. I just heard that there used to be a metaphor for the Marshall Islands being the cockroaches climbing the elephant. And I must say you have gone through an amazing development, Tony, because now everybody is talking about the Marshall Islands being David in its fight against Goliath. And that picture is certainly useful, but only it's useful because we all know that David was the one that was prevailing in the fight between the two. But also, we should not forget that in court cases, the respective actual powers of the two parties to the fight are not a relevant factor. All parties are equal before the law. All parties are equal before the World Court. Each state is entitled to demand that promises made are being kept and that the court will tell the other state so. All state parties to the NPT are under the obligation to pursue these negotiations, and a situation in which less than 2 handsful of states are frustrating the expectations, the rights of the great majority of states is not sustainable and needs to be put to an end. Not by the law of force, but by the force of law. Thank you very much.
Thank you, Phon.